Okay, we're going to get started today. We are pleased to have with us Jennifer Larson from Hagen, Wilka and Archer. She's been a partner with that firm since 2004. Jennifer graduated from Northwestern University and went to law school here at USC. She worked first as a commercial real estate lender for Wells Fargo, and then with the Summit Group as their vice president of finance. And then again in 2004 joined her current firm where she has been working in business transactions, mainly, if I understand right, correct me if I'm wrong, corporate law, real estate law, securities law, and mergers and acquisitions. I'm pleased today to have her speaking on the topic of legal opinions, and we'll turn the time over to Jennifer.
Great, thank you very much. It's very nice to be here with all of you today. I will tell you that it was in this classroom, in the South Dakota practice class, about 12 years ago, that I was sitting where the young man in the red and white striped shirt is, and I first watched Fight Club. Back in those days, not very many of us had laptops, but the guy I was sitting next to did. And now that I see you guys, every single person has one, and so if I see somebody kind of giggling inappropriately, I'm going to have to think that you're watching a movie in the class. I imagine you all have figured out ways to avoid that these days as opposed to us. Understood. All right. Well, today you guys are going to be treated to the topic of legal opinions. I apologize for doing this to you, but I will start by telling you that most of you will never write a legal opinion in the formal type of legal opinion that we're talking about today. Generally speaking, they're restricted to transactions, not litigation. And generally speaking, well, honestly, most transactional lawyers don't run across them. It just kind of depends on who your client base might be. But we'll talk through them. Certainly stop me and ask me questions as you have them, and it will be a much more interesting class than if you just listen to me talk. First, you want to know what is a legal opinion. A legal opinion is a statement by a legal professional concerning an action, condition, or intent being within the law. So again, let me repeat that. It's a statement by a legal expert concerning an action, condition, or intent being within the law. Let me start maybe by telling you what a formal legal opinion is not. It is not advice. You guys are going to give advice all the time. And whenever we talk about legal opinions at my firm, one of the attorneys always pipes up and says, I give opinions all the time. Yes, you do, but we're not talking about informal opinions or just advice that we all give to our clients daily. We're talking about a formal legal opinion. There's a difference between advice and a formal legal opinion. Advice is generally your client will give you facts and you will apply the law to it and give them some analysis. So you're talking more about the law. In a legal opinion, a formal legal opinion, you are stating the facts. Something like, these documents are enforceable in accordance with South Dakota law. That's a fact. These documents are enforceable. So you are stating the facts in this case based on your knowledge and research of the law. You can accidentally give opinions. And I would recommend that you try not to do that. I ask the lawyers in our firm to not use the word opinion if you're not giving a formal legal opinion. And it can come up in all sorts of situations. In fact, I'll tell you of a situation that I caused, or a challenge I caused for another attorney a few weeks ago. I had a client with a transaction that was closing in another state. The documents were enforceable under New York law. It wasn't the kind of deal where we wanted to pay for or spend the time on a formal legal opinion, but I wanted a New York lawyer to look over the documents and tell me, yeah, these are okay, Jen. So watching that attorney try to draft me an email that didn't say, here's my opinion, or use the language that you would normally use in a legal opinion was really kind of tricky and kind of fun to watch him squirm through that, because he was trying his best to not give an opinion and just say, what you've given me, Jen, is okay. Do you have a question? Huge. Generally, for advice, you're charging on an hourly basis. For opinions, it can be thousands of dollars. And with that particular firm, and the client I was using, they charged that client $20,000 per opinion. So as opposed to, I think it was $1,000 or so otherwise. So it can be a really significant difference. And we'll talk more about how to bill for opinions kind of towards the end of the discussion. So again, my advice is don't accidentally give an opinion. Just avoid the word if you can help it. I apologize for how we, attorneys who give opinions regularly, refer to them. But opinions, when we say I have to give an opinion, we generally mean it is an opinion letter. It's in the format of a letter. And within the opinion letter, we give some very specific, discrete opinions about the law. But we refer to both as opinions, and I'm going to refer to both as opinions, both the discrete statements you make as well as the letter itself. So if you get confused, let me know, and I apologize for that. You need to know a little bit about some of the standards that we apply to opinions. First of all, you are giving the opinion to someone on the other side of the transaction from your client. So you have your client, but you're giving the opinion to someone on the other side of the transaction. In all likelihood, they have the exact same set of documents that you do. And they have zero responsibility to read those documents and make sure that what you're saying is true. So if you say something that's not correct, and they could have easily found out it was not correct by just reading the documents they have, you're still liable for it. An opinion is kind of like a mini insurance policy. If I give an opinion and the other side relies on it, and the opinion was wrong, and so they suffer some damages, they can sue me on my opinion. So there's some risk for all of us. Another one of the standards applicable to opinions is, generally speaking, the good news is they don't really apply to local or municipal law unless somebody really wants to know about a very specific area of law. So you don't have to worry about that in your opinion. Also, you generally don't have to worry about more specialized areas of law like tax, bankruptcy, securities law, that type of thing. Those are outside of the opinion unless you've been specifically asked to consider those items. Another thing for you to consider is, can inside counsel, in-house counsel at a company give an opinion, or does it always have to be outside counsel? It could be either. Because of the cost involved with opinions, it would be really tempting for a lot of in-house counsel to probably do that. I do not see it happen maybe ever, but it's possible. And the in-house counsel doesn't really necessarily want to give the opinion either, because their practice has become really general. They're looking at whatever shows up on their desk from their company. It's not like they work on real estate transactions every day, and so they have been working knowledge of a real estate transaction that maybe I would. So a lot of times in-house counsel won't want to give the opinions. There are some ethical considerations that you need to keep in mind. Number one is Rule 2.3. And this is the rule that you guys probably don't have memorized. I didn't. Is that a lawyer can provide an evaluation of a matter affecting a client for somebody else's use if the lawyer reasonably believes that making the evaluation is compatible with the other aspects of the lawyer-client relationship. Here's the trickier part. When the lawyer knows or reasonably should know that the evaluation is likely to affect the client's interests materially and adversely, you need to not provide the evaluation unless you get informed consent from your client. And I'll give you an example on that. I am commonly asked to give an opinion that says something to the effect of, to my knowledge, the client is in compliance with its material contracts. So there aren't any defaults under whatever kinds of contracts they may have out there. It's a risky kind of opinion. We'll talk more about it later. But what if somebody asked me to give that opinion and I know very well my client is in default on one of its contracts? At that point, I talk to my client, and generally they end up talking to the party on the other side so that they can have a more business person level discussion and let the other side get comfortable with it before the attorneys get all freaked out about it. And then the attorneys work on how to paper it over in the opinion. The other piece about this is, except as actually is disclosed in the opinion letter, the information that you review is subject to confidentiality. So you guys need to keep those pieces in mind as well. Another ethical consideration for you is you need to be competent in whatever area of law you are asked to opine on. So if you spend all day litigating DUIs, you should probably not be giving a real estate opinion. Just make sure you are competent in an area. I mean, I won't give opinions on bankruptcy or tax matters, for example. Another piece or another ethical consideration is if you have a financial interest in a client. For example, one of the clients that I regularly give opinions for is a public company, and I own their stock through a mutual fund. Well, I need to disclose that so that whoever I'm giving the opinion to is aware of that, so that they're not afraid that I'm going to, say something within my opinion based on my financial interest. My financial interest is about this big, so it doesn't really matter, but it still needs to be disclosed. And honestly, it's probably a risk for me to do it, but it's one in this case I'm willing to take. Next thing to consider is the appropriateness of the opinion itself. I will tell you, there are some clients you don't want to give opinions for. Maybe you don't trust their business practices and you think they're ridiculously sloppy, and it's going to put you at risk because you're never going to get the real information. Or maybe you don't trust the client, period, in which case you should probably just fire them, but sometimes it takes a while to weed some of those out. So you really need to consider, do you want to give the opinion for this particular client? Another consideration is the type of opinion, the size of the transaction, and its scope. I was telling you about this client of mine that I have a financial interest in. They had a $600 million loan close a couple of months ago, and I wrote an opinion for it. I tell you what, if I got sued because I screwed something up in the opinion and had a judgment against me for $600 million, I wouldn't survive financially, and neither would our firm. But, again, we think, given the relationship and the knowledge we have of this client and the limited scope of what we were asked to opine on, that was reasonable. And so our firm decided that was an acceptable risk to take. You want to limit the opinions that you give to the extent reasonably possible. And most of the rest of our discussion today is going to be talking about how you narrow the opinion and how you limit your risk. So pay attention to that. And it is very possible to do, and it's very reasonable to do. Again, the opinions are factual in nature. And sometimes we have issues where there is some factual or legal uncertainty. And first of all, you try and do more research or more due diligence and get a better grip on the facts of the law. And if that is not possible, but you still need to give the opinion, you need to carve out some exceptions with the opinion that talks about what it is that you are uncertain about. All right, let's talk about situations where generally we give opinions. It's very common in merger and acquisition transactions, and typically the buyer of the company, whoever's going to end up with the new company, wants to have the seller provide the legal opinion so that you know what they're selling is valuable. You know that their company was organized appropriately so that when they merge into the buyer ends up with a healthy company. Loan transactions are really where I spend almost all of my time in legal opinions. And here, the lender asks the borrower's counsel to provide the opinion. Securities, sometimes we give opinions. Maybe one of your clients would be issuing stock to a third party or an employee or to investors, and they may want from you an opinion on, first of all, whether those securities are deemed securities under securities regulations, and whether, if they do offer those securities and they are deemed securities, do they have to register the securities and register the offering with the SEC. The goal is always never to register. Sometimes you get tax opinions. We used to do it a lot when LLCs were relatively new, and we would get opinions from tax counsel that yes, this transaction, or yes, the way you have the company structured will result in the LLC being taxed as a partnership so long as you don't do X, Y, and Z. We don't really do that nearly as much anymore because we're all a lot more comfortable with LLCs and what the real tax effects are. Single purpose entities and non-consolidation kind of run together. Many lenders will ask that a borrower be a single purpose entity, and that is an entity that owns essentially one asset, say an apartment building, and that lender is going to lend based on that apartment building only. But if your client has a whole bunch of other companies that own other apartment buildings, there is a risk that if the parent company or one of its subsidiaries files bankruptcy, that this one company our lender is worried about could get sucked into that bankruptcy. They really don't want to be involved in an affiliate's bankruptcy. So there are some really kind of unique and wonderful ways under Delaware law that you can structure these to make sure that that doesn't happen. And in those cases, generally, you'll need to get opinions that it's been structured appropriately. The other thing about opinions is they are not given nearly as frequently as they used to. And there's a few reasons for that. Number one, they're just flat out expensive. And you don't want to spend the money if you don't have to. Second, the other side of the transaction has access to exactly the same information that you've got in almost every situation. So why can't they just look at the documents instead of you looking at them and make the determination of whether or not it's a decent deal to enter into? And I'll give you an example of that. I've had situations where, for example, a lender is based in Georgia, their counsel is based in Georgia, the documents are enforced under Georgia law. And they want my client, the borrower, to hire a Georgia lawyer to review the lender's Georgia lawyer's work and say that they're enforceable in accordance with Georgia law. That one I always fight back on. Sometimes I win, sometimes I lose, but that's a great example of sometimes it's just not really necessary. And then the last reason that there's not so many opinions given these days is they're really never enforced. I am not personally, I don't have firsthand knowledge of any opinions being enforced. I have a couple of very, very old examples of opinions being enforced that are, kind of third-hand knowledge. So if nobody's going to really enforce an opinion anyway, why make people undergo the expense and the time and the hassle to get it? So they aren't given as much as they used to be. All right, next. The law covered by the opinion. You need to be really clear on what law you are expected to know, and your opinion will state it. This law covers, or this opinion covers no law other than the laws of the state of South Dakota and United States law generally applicable to transactions such as this. It will get really specific. In many cases, we'll make the opinion even more specific if we can. Again, this is part of our narrowing our opinion and our responsibility, and say things like, we're covering the law under the South Dakota Limited Liability Company Act, and not other areas of South Dakota law, just the Limited Liability Company Act. So again, this is a great place for you to narrow your opinion and reduce your risk, and you state it within the opinion then. Some of the elements of the opinion. What I'm going to do now is kind of verbally walk you through the different parts of the opinion, and then of course we'll have chances to actually look at what the opinion looks like in a bit. It is truly a letter that you are writing to the other side. So the addressee of your opinion letter will be the lender in a loan transaction or the buyer in a merger, that type of thing. You state right up front what the transaction is about. This is regarding a $10 million term loan from XYZ company, the lender, to ABC company, the borrower, and you talk about what the agreement concerns. In the opening paragraph, then, you talk about your role. I typically do not want to say that I'm counsel or general counsel for a client. I try to narrow it if I can. Often we'll say that we are special counsel, which implies that we're hired for this transaction. Now, I don't know that that would actually be effective and help narrow my liability at all, but it doesn't hurt to try it. If I'm hired by somebody as part of maybe a larger transaction and they have one mortgage in South Dakota that they need an opinion for, I will state that I am South Dakota counsel. So it's clear that I did this one little piece of the transaction and I didn't do the rest of it. And so I don't have any responsibilities in that way. We date our opinion letters just like you would date a letter. The good news about that is the opinion is effective as of that date. Generally, you date it on the date of closing of whatever the transaction is, and you have no obligation to update information after that. So some of the work that we have to do is some opinions require a fair amount of due diligence. And I'll give you some more examples of what kind of due diligence you might have to go through a little later. But you are going to need to recite some of the due diligence that you do in your opinion. And it just takes some practice to kind of figure out what's material, what's not material, and what's appropriate in this context to be listing. But again, we'll go through the examples in a bit. You do want to identify facts that you rely on in giving your opinion. And that includes documents that you've reviewed that are truly relevant to your opinion. You can rely on facts given to you by other people. For example, maybe you could be asked to give an opinion that the company is not party to any litigation and has no known threats of litigation. Well, that's not necessarily something you're going to know unless somebody tells you about it. And it's really hard to research all of the courts in the country to figure out if there's some kind of litigation out there. So you might get a certificate from an officer of the company who tells you, we don't have any litigation outstanding and aren't aware of any threatened litigation. Content for some of those officer certificates is you want it to be fact specific. You don't want them to just repeat the opinion that you're going to end up having to give. That you don't want them to repeat, this document is enforceable in South Dakota. That's a legal conclusion, although you state it as a fact that you're supposed to give. So they need to give you truly more factual information. I'll tell you that I've tried to get past lenders every once in a while when I've got a situation that I'm just not quite as comfortable with, try and get them to buy off on the idea that I'm getting broader legal conclusions from the clients, and sometimes I can get away with it and sometimes I can't. You also want to make sure that when you're getting a certificate from the company that you're getting it from somebody who's appropriate to give it, somebody who's probably an officer of the company and who actually has some knowledge of that area. So if you're asking about litigation, if they've got in-house counsel, you want the certificate from their in-house counsel, as an example. If you've got some tax matters, you can get certificates from accountants. You can, if you're having to deal with the law of another state or some other specialized area of law, you can get information or certificates from other attorneys. You can also get certificates and information from public officials, and you'll do this a lot if you're giving opinions. For example, if you're giving an opinion about the due organization of a company under South Dakota law, well, you're going to ask the Secretary of State to give you a certificate that the company is in good standing. It was formed under South Dakota law and it's still in good standing. And that's a certificate of a public official. And again, all these certificates you list in the opinion. You can get certificates from zoning officials if you have to give some kind of zoning opinion or something like that. You do not want to allow your officers to give you certificates about issues that you really should be obtaining from a public official, though. So go to the public official first, and if they don't have that ability, then you can go to your client. So you list all of these documents you review, you list these certificates you review, and you describe them in your document so that it's clear to everybody where you're getting your information from. The next thing you do is you state a bunch of assumptions about the opinion. Again, this is helping you narrow the focus of your opinion and limit your risk. So they might be things like all of the parties who, I assume that all of the parties who signed these documents, except for my client, were competent, or all of the parties who signed these documents, except for my client, were authorized to do so. Because I'm going to have to figure that stuff out for myself about my client, but about everybody else, I want to make sure that they also meet those standards. And so you state all of those assumptions in your opinion letter as well. Again, if you have maybe some unreliable information or something that causes you some concern, you need to list some of the assumptions that you made about that information and state that right in your opinion. If you can't do enough due diligence to figure out what the right answer is. Then we finally come to the meat of your opinion letter. And this, honestly, you're at about page 4 or 5 of the document by this stage. And this is about the shortest part of the document. And it's where we talk about the actual opinion or opinions that you are giving. The opinions that say things like, these documents are enforceable in accordance with South Dakota law. And so what do we do immediately after that? We give them these discrete opinions, and then we qualify them. So we've had a bunch of assumptions about them, we state the opinions, and we further qualify them. And we'll say things like, despite the opinion I gave, it's subject to bankruptcy law or courts of equity and any equitable decisions that they might make. Say, for example, you're giving an opinion about a mortgage, and yes, the mortgage is enforceable under South Dakota law. Well, if that borrower ends up in bankruptcy, things will change. Or if some court decides that the lender's behavior has been so egregious that they are going to use their equitable powers to reform the document or to alter the remedies, then, again, that's stuff that you can't necessarily predict. So we qualify those out of the opinion. You also want to list exceptions that might be based on state law. And I'll give you an example. In South Dakota, we have mortgages that have different redemption periods, and redemption periods are if you get foreclosed on your mortgage, after the foreclosure sale happens, you have another 180 or 360 days where the borrower can go back and buy their property back out of the foreclosure. Well, 180 days, obviously you want to go with the shorter one, right? Makes sense. Except there's some restrictions on some of the remedies that you have available to you as a lender. So a lender, may be using a 180-day mortgage form, and here you'll qualify. Your form's generally enforceable. However, you may not have the right to seek a deficiency judgment if the property sale wasn't enough to pay off your loan. And so you need to know the law well enough to know what those exceptions are, so that you can state them in your opinion. Those get tricky because you have to know the law well enough to know what those exceptions are, and really do your research. I mean, the first time I wrote a South Dakota mortgage opinion, I sat down with the statutes and checked off the items and walked through their document to see where their document might conflict with South Dakota law in that regard. And it's one of those things where once the lender sees that form of opinion and sees that issue, they can then choose, wait a minute, is there a way I can get around this problem? Can I draft it differently? And then you can talk about some alternatives. But generally, they want to go that path, and they're okay with it. They just need to know that, yeah, it's enforceable. I just might not have all of the remedies available to me that I would otherwise. One of the really big qualifiers we add is the knowledge exception. I might give an opinion that says, to my knowledge, the company is in material compliance with all of its contracts. Well, the question is, so what's knowledge mean? Is it just me? Is it everybody in my firm who has ever worked with this client? Is it just what I know about this client from this transaction? Or is it every file that we have ever worked on for this client, and I have a duty to inquire further and do more research to make sure that it's really true? Obviously, you want to narrow knowledge as much as possible, and the party receiving the opinion wants you to broaden it. It usually ends up somewhere in the middle. Other ways that you need to qualify your opinion are for things that happen after closing. For example, yes, the mortgage is enforceable in South Dakota law if you record it in the appropriate county. Yes, the UCC financing statement will be enforceable to perfect your security interest under South Dakota law if you file it with the South Dakota Secretary of State's office, that kind of thing. So if there's some action that the lender needs to take the moment after closing to really make your opinion work, you need to state what those actions are. Again, we have this whole qualification about what if there's some kind of uncertainty. Spell it out. And then you want to, this is the place where you specify, I'm only opining as to the laws of the state of South Dakota. As we get to the very end closing paragraphs of the opinion, we will state things like we don't have any obligation to update the information in the opinion, and the opinion speaks for the date that it's written. Another thing that I've seen only one time that I thought was kind of clever, but I've never done it myself, is I had a large transaction, I don't remember how much, maybe $100 million, and had counsel I was working with. I was kind of the lead counsel for the borrower, and working with counsel all over the country because the borrower had properties all over the country. And so I had to go find counsel in each state where they had a property and where there was going to be a mortgage. And I had to get a mortgage opinion from each of these other states' counsel. And so lawyer in Colorado says, this is a $100 million transaction. I really don't want to write an opinion on a transaction that significant. So their request was that we limit their liability on the opinion to the amount of their malpractice policy. And the lender agreed to it. So I thought that was kind of clever, and it worked. There are form legal opinions. And the American Bar Association years ago got a bunch of lenders council together and borrowers council together and buyers and sellers council and merger and acquisitions and that type of thing. They formed committees and developed forum opinions that were reasonable and kind of middle of the road. Instead of trying to negotiate from opposite spectrums, you can start in the middle with these accord opinions. I really don't ever see them used. However, they can be used. I know my partner has used them, for example, in mergers and acquisitions when they're just struggling, negotiating with the attorneys on the other side about what the opinion should really say. If you go to what the ABA has said is reasonable, sometimes it provides you a little better starting ground. So you can always look to those as well, and those are all on the ABA website. Okay, so do we have a break that we take it at any point, or are we going through?
It's up to you.
Doesn't-
You can continue through, or we usually take it at 10 if you want to take it.
It doesn't matter to me at all. Okay, would you guys prefer a break in a little bit? Keep it rolling? I'll keep it rolling. All right, thank you for giving me your thoughts. Okay, so next is what types of opinions do we regularly give? And what kinds of due diligence do we look at? For this, you guys have your in-class hypothetical and your answers. And we're going to kind of walk through all of this together. Start with the hypothetical. So we have ABC Manufacturing. This is the seller. This is the parent company. And ABC owns Subsidiary Inc. ABC is selling off all of Subsidiary Inc. And XYZ is going to buy Subsidiary Inc. So they're selling the stock so that when XYZ takes ownership, they've got all of the stock of that company, which means they own everything that is part of that company. All the assets, all the stock, everything that's part of that company, all the liabilities, everything that comes with it. They do this through a stock purchase agreement. And in this particular case, the parent company, the seller, says, we'll agree to finance this for you. So instead of getting a bank loan, the seller provides the financing. The security for this particular transaction is the stock of the subsidiary itself. So the buyer gets the stock and the whole package that comes with at the closing, but the seller keeps a security interest in that stock. So if there's a default, they can take that stock back and they can get their company back. You accomplish that generally by handing over the stock certificate so that the seller, the secured party, will hold onto the stock certificate and have possession of it. And they have a document called stock powers, which to me still spooks me every single time I deal with it. But essentially what the stock powers says is, XYZ company, who's the borrower here, owns this stock certificate of Subsidiary Inc., because this is now after the transaction, right? And if we default on the loan, we hereby give our stock to ABC, who's the lender in this case. That to me is really scary because they have that document and they have the certificate. So they have all the control of or at least they've got the upper hand in taking control of that company over again. So that's kind of how this particular hypothetical is laid out. So as you go down farther in the hypothetical, they're going to ask for certain legal opinions. One, they want a due formation opinion that ABC Manufacturing is duly formed under the laws of South Dakota, and it's in good standing in South Dakota. That is a really common opinion. They want an opinion that they were duly authorized to enter into such a transaction, and that it is okay under their organizational documents, and the person signing those documents has the authority to sign and sell the stock of the company. They want a capitalization opinion. These are scary because there's a lot of work in them, and many clients have not done a great job of keeping track of their corporate records. And the capitalization opinion says this is exactly who owns the stock, and it's all been issued in accordance with law and with the company's organizational documents, and there are no outstanding rights, licenses, warrants, or any other document that might give somebody else a right to that stock. They want a basic enforceability opinion, and this is the one we've talked about so much today, and that's the opinion that says these documents are enforceable under South Dakota law. They want a conflicts opinion, which is not a conflict of interest opinion. It's an opinion that says this transaction and these documents do not conflict with the organizational documents of the company, or they don't conflict with the law of your state, or maybe even they don't conflict with other documents, other contracts that that party is party to. And then finally, they ask for a no proceedings opinion, which says there isn't any litigation outstanding against the seller that we're aware of, and none would be caused as a result of the stock purchase agreement. So the next page gives you a long list of all of these documents that you have access to. All sorts of organizational documents, documents that tell you who's authorized to sign. They talk about not only XYZ company, but they also talk to you about the subsidiary. You've reviewed things like the stock purchase agreement, the note, the security agreement, the stock powers. And then we list some other documents. They're contracts for raw materials purchases, which is obviously going to be a really important document to them, but it might not be material to this transaction or to the opinions you're being asked to give. So there's can be all sorts of information that we have access to as we're doing our work and our diligence on this opinion. And so then we're asked to draft the legal opinion, and we are entitled to assume that every document is enforceable under South Dakota law, and we're entitled to assume that the people who are given authorization actually have received the authorization as required by their documents. So that's the basic form of the transaction we're looking at. Okay, so now we're going to walk through the opinion letter itself. The first thing I really want you guys to focus on, and it's important for your assignments. So listen closely, please. There's a lot of differences between corporations and limited liability companies. You need to know which one you're dealing with. And I will tell you, it's just kind of a helpful practice tip. Other attorneys can spot rookies or spot people who are not knowledgeable in the transactional area of law if they make mistakes referring to corporations or LLCs in their documentation. So you really want to pay attention to it. And I'm sure that not all of you have taken business organizations. If you haven't, ask your friends so that you get some help on this. All right, so we have corporations and LLCs in our small little world here. Corporations, their ownership is evidenced by stock. Who knows what LLC's ownership is evidenced by? What do you call it? I'm sorry? Exactly. Membership interests, membership units, that's the ownership instead of stock. When you're referring to a corporation, you generically call them the corporation. When you're referring to an LLC, you generically refer to it as the company. So LLCs have members. Those are the people who own the membership interest. What do corporations have? Shareholders, precisely. A shareholder will have a board of directors, a corporation will have a board of directors. The LLC has a board of managers. Now, not every LLC has a board of managers, but if they've got a board, it's a board of managers, not a board of directors. When you're filing documents, to initially incorporate your corporation, you file articles of incorporation. What do you file for an LLC? Does anybody know? Articles of organization. That's what you call them in South Dakota. Different states have different names. In Delaware, it's a certificate of formation. And other states have other names as well. So you need to kind of pay attention. And like I said, you will stand out as either a new lawyer or a lawyer kind of practicing outside of your regular area if you don't get these right. So you'll want to look like you know what you're doing, and in this assignment as well. Okay, so the first opinion we're asked to give is the opinion about corporate status, right? And so what we do is we need to, again, differentiate between being duly incorporated or duly organized, depending on if we're a corporation or an LLC. We look to the articles of incorporation or articles of organization. You can get certified copies of those documents from the Secretary of State in each state in the country, so that you know that the document you have in front of you is the one that really was filed. And if there were any amendments filed to those articles, you can also get copies of those. So you know that you're looking at the most recent articles for that company. And that's very typical for you to get those certified documents. You get those, and you'll get what's called a certificate of good standing, which essentially says this corporation or LLC is in good standing under the laws of the state of South Dakota or whatever state. Again, every state calls those certificates something a little different, but South Dakota's, but we generically refer to all of them as a certificate of good standing. Now, if you have those things, if you can see the articles and they were filed in South Dakota, if you got a certificate of good standing, if you can look back in their corporate record books and see the minutes of the meeting that led to their incorporation, you generally can tell that, yeah, they're duly incorporated or duly organized under the laws of the state of South Dakota. That one's not too bad. Do you guys have questions about giving that opinion or what you look at? Okay, so the next opinion, and actually, you know what, you can look at the opinion document, which is on page 3, where we start labeling these with ABC. A is the very simple opinion. They're duly organized, validly existing, and in good standing. Our next opinion that we've been asked to give in this hypothetical is a corporate authority opinion. And this says, not only does the company have the ability to enter into this transaction, but the individual signing the documents has the ability to sign on behalf of the company. And for these, you typically look at the bylaws for a corporation or the operating agreement for an LLC. And you also can look back through first of all, you need to know the statutes as well, and then also look at other resolutions and that type of thing for the company to make sure that you've got the right person who can sign and that they are authorized to sign, and that the company is able to enter into these kinds of transactions. And if you don't have the right person signing, or the company isn't able to enter into this transaction, you need to figure out what does your client need to do next to make that happen. And one of the things for you to consider in this case also is the fiduciary duties of your officers. Say, for example, there's a transaction that a company is entering into, but maybe it's a transaction with one of the officers of the company. That officer has some fiduciary duties to the company, and it may be very inappropriate for them to be signing those documents, voting on the transaction, and that kind of thing. So you need to consider that type of conflict of interest or fiduciary duty responsibilities also as part of your opinion. And it's not so much that you talk about that in your opinion, it's just that you need to know it so that you're comfortable giving the opinions that, yes, they can, this was validly voted on and it's appropriately authorized and the person is appropriately authorized to sign. All right. When you look at item B in the in-class opinion then, this is pretty straightforward again. The seller has the requisite power and authority to own the common shares, to enter into the transaction documents, and is authorized to sell the common shares and otherwise perform the obligations that the seller is to perform. And the person signing the transaction documents is duly authorized to do so. And that's pretty straightforward stuff. The next opinion is a due execution opinion. Again, in many cases, you want to actually witness your client signing, the person who's authorized. You want to watch them sign the documents. So you can say, yeah, it was really them signing. It's not a stamp. It's not there's administrative assistant signing for them or something like that. The challenges, sometimes your client is not nearby and you don't really want to travel to them and they don't really want to travel to you so that they can watch you sign. What you can do in that case is just have a different officer in the company state that, yeah, I watched them sign, and you can get that in their certificate and be comfortable with them actually executing the document. The opinion, again, on this one is really straightforward. And it is, oh, okay, that's also in B, the last sentence in opinion B. Again, now the meat is the enforceability opinion. The documents are enforceable under South Dakota law. You want to state the exceptions to this, not necessarily in this paragraph, but again, we'll add some qualifications later where we talk about those exceptions. Things like it's subject to bankruptcy law or equitable principles. One other thing, just kind of as a practice note for you guys in South Dakota, many lenders will ask you to give a usury opinion, which says, is the interest rate I'm charging acceptable within state law? In South Dakota right now, there are no usury laws, which is why we have so many credit card companies here. But in many states, they do have usury laws, and they can be pretty restrictive, particularly on residential type transactions. So usury opinions are relatively common. But here, we typically don't have to worry about it too much. Another opinion that we're often asked to give is one that says there aren't any conflicts with the organizational documents of the company, with any laws that we're aware of, or sometimes they'll even ask you to give an opinion about whether the transaction would conflict with any other contracts. And I'll give you an example. Say if we're dealing with a loan, this borrower may have tons of different companies and lots of different loans out there. And one of the loans might say the parent company can't guarantee any of its subsidiaries' debt. Well, if the transaction you're dealing with today says my parent company is going to guarantee this debt, you've got a conflict issue between different transactions. Those are risky opinions to give an opinion that there aren't any conflicts with other documents, because how in the world are you supposed to know all of the different contracts that your clients entered into? You really want to try and narrow those to things like material contracts listed on Exhibit A, and then so you can get the lender to tell you what are the really important contracts that my client's dealing with, and so you just have a limited universe of contracts that you have to work through. But if you can avoid those opinions, you want to, because they can require a fair amount of due diligence. And that opinion is E. The execution, delivery, and performance of the transaction documents will not contravene, violate, or cause a default under any government, regulation, law, or ordinance, their organizational documents, or any other agreement to which they're a party. All right, next opinion is a capitalization opinion. And this one can be really tough because I'll give you an example of a client of mine that I've never had to give an opinion for, thank goodness, because they are sloppy business people. They are not very good at keeping track of their transactions. They kind of shoot from the hip, and they only call their lawyers when they think there's a crisis. And so when they think they're okay, they go ahead and do the rest of they go on with their business, whether or not they really know what they're doing. So, for example, over the course of several years, they have issued, it's an LLC, and they have issued membership interests to all sorts of different members. Their operating agreement has some really specific provisions about how you authorize and issue membership interests, and generally speaking, they don't have any records that shows that they actually follow those steps. That's an issue. I would never in a million years give them a capitalization opinion because I could never really come up with the due diligence that showed that the shares or the membership interests were appropriately authorized, they were appropriately issued, that what's outstanding is really all that's outstanding. I had another client recently who sold their company, and we discovered after closing that maybe the selling company really wasn't all that sure about the ownership of this one guy. And there was a question of, does he own 1,500 shares of stock or does he own 1,506 shares of stock? And so I'm asking the president of the company, who's the guy who's dealing with all these transactions and handling all of this work, and he says, I don't know. As it turns out, the people who bought the company were very forgiving, and it wasn't that big of a deal, and the shares are virtually worthless anyway, so who cares if it's 1,500 or 1,506? But some people would really care about that. So capitalization really requires some thorough due diligence, and if you guys are going to give that opinion and your clients are asking you for an estimate of your fees, estimate really high. So that is opinion D. And here you can see that I've really tried to narrow this opinion based solely on the organizational documents, the officer's certificate, and remember now my officer is saying we have validly authorized and issued the shares with these stock certificate numbers to these shareholders. And so they're giving me a certificate, essentially an affidavit saying that all of that's true. And so I've narrowed my world in this opinion to that limited set of information so that if there's other stuff out there that I can't find, I'm not going to be held to it. And then we say, and therefore all of that we've narrowed our world to is duly authorized, duly issued. There's no other outstanding shares. Oh, and by the way, there aren't any other voting agreements or proxies, warrants, or other rights to purchase that stock from anybody that we have on our books. Next opinion is an absence of litigation opinion. You really want to limit this to your knowledge, and again, you really want to limit the definition of knowledge because people get threatened with lawsuits all the time. If you own a retail store and somebody slips and falls at the front of the store and they haven't threatened you, they haven't filed a lawsuit, do you still have notice of a potential litigation issue because they've got injuries and you're aware of it? I mean, so that kind of opinion, it can get really broad. I try and limit my opinion on those to an officer certificate and let the officer determine what's maybe real and seems material and what isn't in terms of what's been threatened and what lawsuits have actually been filed. That's opinion F in your example. And not only are this also can really be limited to a materiality standpoint. If you've got a hotel company, people slip and fall in hotels all day long. And those are common accidents, and generally speaking, they are going to be covered by insurance. Lenders don't consider slips and falls, even if it's risen to the level of litigation. Typically, they are not going to consider those to be material unless it gets to be a really significant dollar amount in the claim. Another type of opinion, and we don't have this in our hypothetical here, but one that sometimes you may be asked to give is about the transfer of assets and title to those assets. Real property is one of those. In South Dakota, we don't have to give that opinion because we have title insurance here, and it's easier to actually buy a policy of title insurance stating that the buyer now owns the property and has valid title of the property than it is to hire a lawyer to go to the county, research all the records, and write up an opinion about what they found. I mean, I'll be honest, you can get abstracts of title and you can give opinions of title, but I've seen one in my 12 years of practice. I mean, you just don't do it because you have title insurance. In Iowa, they do it. So, you be aware that in other states they might, but in South Dakota, no need to give a real property title opinion. You may be asked to give opinions about the priority of UCC financing statement filings. Interestingly enough, you can also buy UCC insurance, and you can get it through title companies, and they will insure the priority of a UCC filing over a particular type of asset. And so that can be handy too. I've only seen UCC insurance used in a couple of transactions, but it's a possibility. Otherwise, it's not that hard to get certified records from the Secretary of State about a particular party and be able to determine who's got priority of filings. You future litigators may be wondering, well, where are all the litigation opinions? We've talked about transactional opinions. There really aren't so many. Every once in a while, you may be asked to give an opinion about a particular type of remedy, but it's relatively rare. Partly because, even the transactional lawyers can give remedies opinions in something like a mortgage. For you guys that will be litigators, you're usually into the lawsuit by the time you're asked for information, and so it doesn't really matter anymore what the documents, to get the opinion, because the documents say what they say, and now you have to just deal with it as it is. So litigators do not give many opinions at all. Let's go through the rest of the hypothetical and just kind of walk through it. It won't take us very long. Again, it's definitely in a letter format. You address it to the party that you're giving the opinion to, which is always the other side of the transaction from your client. You introduce the topic, and then in the first paragraph, you tell them who you are and who you're representing and your capacity, your special counsel, your general counsel, your South Dakota counsel. And then you list all the documents that you've reviewed that relate to this opinion. So back to our hypothetical, we go through the transaction documents: the stock purchase agreement, the note, the security agreement, and the stock powers. Those are our 4 transaction documents. It's pretty straightforward. And then we talk about the organizational documents and list those, and we talk about the certificates that we've received from the officers of the company. You'll note that some of those other contracts and things that showed up in the hypothetical aren't on this list because they're not material to the opinions that are being given. So everything in your hypothetical does not need to be on your document list because it's just not going to be material to the particular opinion. And then, so we go on, and now we're talking about the assumptions that we've made. Everybody other than our client validly executed every document. They were appropriately authorized to execute every document, and their signature represents the binding obligation of that party to the document. And the reason you want to make that assumption is, say you have a loan, there's a loan agreement, and there's a borrower and a lender who sign the loan agreement, right? So your client's the borrower, and you want to make sure also, though, that for the loan agreement to be enforceable, it's signed by the lender. Because if the lender did not have authority to sign it or didn't sign it in the first place, it's not an enforceable document. So you need to make assumptions about some of the other parties in the transaction. You assume that parties are competent, and you assume that signatures are genuine and nobody's forging signatures. You assume that the deal didn't change after the documents that you received, and that's a trick. Because a lot of times in a transaction, people will go through many, many drafts of documents, and you need to make sure that you're dealing with the latest draft. And that there was no side letter or something that changed some provision in the documents that you weren't asked to opine on. And then one that's also another really helpful kind of assumption is to say we also relied on all the facts that are stated in the representations and the warranties in the documents. We relied on those too. Okay, so then we go through our opinions, and we've already gone through those. And next we go on to now further qualifying the opinions. Excuse me. The qualifications in this particular case are that they're subject to bankruptcy and equitable powers of a court. We don't state or make any opinion about any laws outside of the state of South Dakota or U.S. laws generally applicable to this type of transaction. We qualify that we do not express any opinion as to the title of any of the documents or the priority of any liens. And that would seem kind of counterintuitive if you're giving an opinion about a loan transaction where there's a security interest, but it's really not. You don't want that responsibility. Again, the title company can handle ensuring that, and you don't want to take on that responsibility. We give yet again another kind of assumption about the authenticity of all of the documents, and then we define knowledge and try and narrow our definition of knowledge as much as we can. And then we close out the opinion, and this is pretty easy. The opinion is as narrow as we can make it, and it's limited to the information that's set forth in this opinion letter. It speaks as of the date of the opinion, and we are not going to update it later. And it's only for the lender's use or the party that you're writing the opinion to. It's only for their use, and nobody else can rely on it. You want to make sure that you don't end up with some third-party beneficiary in there. And that's an opinion letter. So the assignment that you guys are given looks a whole lot like the hypothetical that we just reviewed, but it is different. And I've given you a couple of tips on some of the things to watch for. You also need to really pay attention to what opinions are you being asked to give, and look at the opinions that were given at the example that we just went through. Couple of practice tips. Many firms have opinion committees, and every single opinion that goes through that law firm has to be reviewed by the persons on that committee. So a lot of times I'll be working with counsel in another state, asking them to provide an opinion on something, and they will be fighting with me saying, I'm sorry, my committee's just not letting me give that opinion, or they need me to revise it this way. And I mean, they get all sorts of issues. At our firm, we do not have an opinion committee. We caucus and talk about opinions when we're concerned about an issue, but we don't have an actual committee that approves them. But if I need an excuse sometimes to not give an opinion, I will say my opinion committee did not allow me to give it. When you sign an opinion, there are two schools of thought about how to sign it. You can sign it with the firm name, or you can sign it with your individual's name. My preference is I do not sign it with my name. I sign it Hagen, Wilka, and Archer, LLP. And I sign it that way as though the firm has a signature. Some people sign it with their personal names because they figure I'm the one who did all the work. I'm going to put my name on this. But I kind of feel like this isn't a firm issue. If somebody's going to get sued, it is the firm. And so I put the firm name on it. Associates should not be signing opinions. You should be a partner before you're signing opinions. So if you're being asked to give opinions, go talk to your partners until you are one. You need, and you know what, I apologize. I skipped on here and forgot to keep you guys up. Opinion letters are very negotiable. And we just talked about a whole bunch of different ways that you can qualify and limit and narrow your opinion. All of that is negotiated. Generally, when you enter into a transaction, the party who's asking for an opinion knows exactly what they're looking for. And you can ask them for a form of the opinions that they want. 9 times out of 10, they will give you a form. The form is not going to have the qualifications, and it's not going to have the assumptions, and it's not going to have all that stuff that we've worked on to narrow the scope of our opinion. It's going to have the basic opinion language. These documents are enforceable in accordance with South Dakota law. That kind of thing. It's going to be very basic. It is also very common for people to ask for more opinions than maybe they really feel like they truly need, and to see how many opinions they can get out of you. I have a partner right now that's working on a really large loan. And so she and I have been working on this one together. And they asked her for, 13 different opinions. And first of all, there were about 4 that were not appropriate for her. They were appropriate for attorneys in the state, in other states. There were about 3 that we just said, no, we're not giving that opinion. It's, not important or not that material, or we're just not going to give it because it's just not a place that we're willing to go in this kind of transaction. And then we qualified a whole bunch of them. And that is okay to do. And there will definitely be some back and forth negotiation on what your form of letter will look like. And that is perfectly acceptable. Do not take what they give you the first time. You do not have to live with that. Everybody's favorite topic, how do you bill for an opinion? This is a value-added service. So you should feel free to do some type of block billing or value-added billing on this. You do not have to stick to a flat fee or a hourly rate. That being said, you, as you know, need to make sure that you have an engagement letter with your client so that they're really comfortable on how you're going to bill for this. For example, on a really simple South Dakota mortgage opinion, I won't do any opinion for less than $2,500. I mean, we have risk. And so not only does it take me time to review their documents, time to research any areas of law that I need to review, time to write and negotiate the opinion, but we have risk because we could be sued based on the statements that I'm making. So I just won't do an opinion for less than $2,500. That being said, there are some opinions, like I said, I have New York counsel who, with one of my clients, they charge a minimum of $20,000 per opinion, regardless of how simple it is. But if their hours that they put into that opinion are more than $20,000, then they'll bill their hourly rate. And with New York attorneys, that can be really high. I have a client, one in particular, who does really large transactions all over the country, and they own properties all over the country. And so they might get a loan for $60 million or $200 million or whatever the number is, and it will be secured by properties in a whole bunch of different states. We could end up with 10 or 15 opinions for this one loan. I tend to give opinions about things like due execution and due authorization. And if they're asking for things like there aren't conflicts with other documents, because that's my client and I'm the one who's going to know their other documents better than anyone else and will know what to look for, I would give that kind of opinion. But if I've got documents that are enforceable under New York law, well, then I have to hire a New York lawyer to give an opinion. If I have mortgages for these New York documents, but I have mortgage in Georgia and Florida and Texas and California, I'm also going to have to hire Georgia, Florida, Texas, and California attorneys to give opinions on the mortgages in those states, because those documents will always be enforced locally at the local level. And so when I'm working with attorneys from around the country on giving mortgage opinions, that type of thing, that are relatively straightforward opinions, I've seen them charge maybe between $1,800 and $25,000. Really depends on the firm, depends on the person you're dealing with, and if they do maybe way too much due diligence or don't know what they're doing, so they don't know the law at all and they're having to start from scratch. And it also has to do with, I mean, if they're from New York City, there's a lot of attorneys in New York who charge $800 or $1,500 an hour, and that adds up really, really fast. So you, and then sometimes there are specialized opinions, like a tax opinion or a bankruptcy opinion. I regularly see those go for $25,000 or $30,000, and they're just, they can charge it because nobody else can give that opinion because the rest of us just don't have that kind of specialized knowledge. If you are in a position where you're having to coordinate some of these complex transactions, start really early because there's a lot to it. And you're going to be in the middle of coordinating all of these documents, opinions between all of the local counsel and the lender or other party to the transaction that you're writing the opinion to. And that just flat out takes some time. It also takes some time to locate attorneys. And I'll tell you kind of my method, which is not anything particularly special. When I'm looking for an attorney in a particular state, if I don't have a good one that I'm comfortable with, I will go through Martindale-Hubbell and find firms that have about a dozen attorneys. And I pick that number because I don't want the firm with 200 attorneys. They tend to be really, really expensive. I don't want the firm with just an attorney or two. And not that that's a bad thing by any stretch of the imagination, but if you have a dozen or so, they've got a good support network of people they can bounce ideas and questions off of. Sometimes, definitely not always. A sign of a solo practice might be somebody who's just decided, you know what, I don't like working with other partners. I like to do things my way. I don't want to do things their way. And that might not be the person that I want to be writing my opinions. So that's my really unscientific method, is I look for firms of about a dozen who have some attorneys who specialize in the area I'm looking for. And then, of course, there's just the competence issue. You need to make sure that you're hiring somebody who actually practices in that area of law and, you know, has some experience. You can ask them, and it's okay to ask, have you given legal opinions before? And you'll be able to tell from the discussion, yeah, which means maybe they have, or maybe they're not quite sure what a formal legal opinion is, to, yeah, absolutely, I do this all the time. I also represent a lender, and so I'm constantly requesting opinions from borrowers, so I know what I'm doing. Those are awesome people to deal with, somebody that really knows the law well. The other thing you are perfectly welcome to do is ask them for a ballpark of their fees. And they might hesitate, and you can tell them, I can't hold you to it, but you want them to tell you, is this a $2,000 bill, or are you the kind of person who's given me a simple mortgage opinion and you're going to charge me $20,000? Because your client's going to be really ticked if you get a bunch of $20,000 bills related to these opinions when it's just a simple mortgage. So you will do your client some favors and stay in their good graces if you talk about fees, and that also helps control the lawyer's desire to charge you once they get to the end. When they're selling you on using their services, they're far more likely to charge you less than on the back end of the transaction when they know this is a one-time deal. They don't really care how much they charge you and if they tick you off. So that's my hint there. That is all of the information I have about legal opinions. Do you guys have questions? Do you have questions about the hypothetical, questions about opinions in general? You guys are a quiet bunch. I think it's because it's 85 degrees in here and you guys are ready to sleep.
Tomorrow on our phone call,
Mm-hmm.
we're all required to come with one question.
Okay. Oh, fantastic.
But
Okay.
But if you want to ask it now and you have it, I'll accept it tomorrow.
Yes.
I just have a question of if any firms, their policy is just to do opinion letters and such that, like, that's just it, like your client asks you to do one, you just give them that blanket statement. Does that fly? You know, if
Yeah.
you're dealing with transactions and then you do, what is the process after that? You just go and find another firm to like handle that specific opinion letter?
Yes, great question. And yes, some firms have policies, we don't give opinions. They're just worried about the risk. One of my partners had a situation about a year ago, and she was doing a very large M&A transaction. And she was kind of coordinating it and had hired another law firm to write the opinion about the merger transaction. And so they're discussing the form of opinion, they're going through the process, they're reading all the documents, they're doing all of this work. And about 5 days before closing, they said, my opinion committee will not let me give an opinion on this transaction. We've been talking about this for 4 months. What do you mean your opinion committee will not let you give an opinion? And apparently they had just made a decision in the recent past that they weren't going to give opinions about mergers. So, yes, some firms say no. Very good question. Yeah.
Is that because of the higher practice area?
You know, generally speaking, the malpractice insurance questionnaires that we have, they ask us about specific types of practice. It generally does not ask if we're giving opinions. And so, no, that is not necessarily a malpractice issue, but there's always that risk of if I say something that, in my opinion, that's just flat out wrong, and it, you know, and the other side relied on it, and they lost some money because of it, I can get sued for it. So there's a risk to the firm.
You're not doing those opinion letters, are you going to lose those type of transactions, and when is the right time to like tell the client that, hey, if this is going to need an opinion letter, you're not going to do it?
Great question. First of all, my advice to you is act as though you're in charge with your client. Hey, we're going to be required to obtain an opinion of counsel for these items, and I'm going to hire so-and-so to do it. And I mean, if they want to take the next step and ask the question, can't you do it? You know, some people won't know that you can, that you theoretically could, but are choosing not to. But, you know, go ahead and you drive the bus. And if they ask you the question, obviously you're going to be honest with them that we could theoretically give the opinion. Our firm has decided that we're not going to. But because I know so much about your company, it'll still be cheaper to have me run the transaction than and just hire the opinion out. Anthony?
You mentioned that the opinions are kind of negotiable, and specifically in terms of the qualifications, kind of go back and forth on those. How do you actually do it? Do you send them a draft, or just an email you say, hey, these are some of the qualifiers we're looking at, what do you think?
You send the draft, and you send your completed draft. This is the letter I'm proposing to give you. And you'll need a good handful of days to negotiate it. So, I mean, be prepared in advance. The closer you stick to whatever form they send you, less negotiation is going to be needed. But and you should also be prepared that as you're engaging in opinion practice, it is one of the last pieces of the puzzle that really gets some attention from the other lawyers. So if you're up at midnight the night before the closing because you're having to deal with the opinion because they didn't get you comments on your draft opinion till midnight the night before, that's part of the process. Yes?
So if you're assuming all this risk and you're essentially sort of like an insurance policy to your client, why does that make your malpractice?
I don't know. They don't ask the question. When you're applying for malpractice insurance and when you're renewing the policy every year, they give you all sorts of questionnaires with all sorts of questions about your practice so that they can assess your risk and charge premiums appropriately. That's not one that I remember ever having to answer a question on, is do we provide formal legal opinions? I don't know why. Here's the other piece of that. It's kind of like I said at the very beginning of this, although you have a risk because it's kind of like an insurance policy in some respects, you Nobody enforces them. So how much risk do you really have? They could enforce it, but they don't. And you know what? You have been raising your hand several times. I'm sorry.
I'm sorry. So you talked about pricing, but how much time does it actually take to write that?
Totally depends on the transaction. If you have a loan transaction where you've got, I've had loan transactions where I've got this much paper, and I've had to read every page. It just takes time, and that doesn't count all of the organizational documents and that kind of thing that I'm going through. So it depends kind of on the size and the scope of the transaction and the nature of the transaction. It can take hundreds and hundreds of hours, honestly. Even if you're a kind of a more minor part, I'll give you an example. I had an opinion that I hired from another lawyer, a Delaware counsel, earlier this year. And the Delaware counsel needed to give me an opinion about the organization and good standing of, it was about 100 entities. But of these entities, their articles of organization and their LLC agreements, their operating agreements, were identical. They just had different names. But because of the nature of their firm, they're the kind of firm that reads every line, it took them a long time. For me to write a pretty simple mortgage opinion, if I don't have to negotiate much, it might take me a couple hours, maybe. Okay, you had a question? No, that's screen out attorneys like from within the firm. Like in my firm, I'd say my knowledge is only related to the knowledge that Jennifer Larson has and not the knowledge of John Archer. I think if you do that, you can do it, but you want to do it more subtly. Because if I say it's only Jennifer Larson's knowledge and not John Archer's knowledge, they're going to be like, well, what does John know, right? So instead, you limit it to only the person working on this opinion and not the other attorneys in the firm. And if they ask you about it, it's, well, you know, we had another attorney that worked on this file 20 years ago. He really hasn't had anything to do with it in at least 10 years, so his knowledge really isn't relevant anymore anyway. So, you can talk about why you want it to be just you, because we don't want to have to go look at our files that are 20 years old. And the parties you're dealing with get that.
I'm going to hold off because we are required to go tomorrow too. So.
Good, okay.
Thank you so much for taking the time to come down to law school.
Oh, my pleasure.
With us. We're very happy to have had your expertise and knowledge. So,
Great. Thank you.